In 1964, Supreme Court case Cooper versus Plate, the United States Supreme Court opened the door for prison lawsuits against those holding them in prison. This set up a precedent that allowed inmates to sue the prisons that were holding them because of perceived constitutional violations and the rights that they have as Americans. This opened up the floodgates, and lawsuits were coming out of the woodwork, to say, suggesting that the way that we were holding our prisoners was completely and totally unconstitutional. These lawsuits became so numerous in the following decades that a plan had to be created, and that plan was called the Prison Litigation Reform Act of 1996. Its intent was to reduce the lawsuits presented and filed by the various inmates from across the country. In 1871, in a court case, Ruffin versus Commonwealth of Virginia, the Virginia Court of Appeals described inmates in this way, and I quote, "For the time being, during his term of service in the penitentiary, he is in a state of penal servitude to the state. He has, as a consequence of his crime, not only forfeited his liberty, but all of his personal rights, except those which the law, in its humanity, accords him. He is, for the time being, a slave to the state." And this held fast and held true in the court system in regards to and the attitudes of inmates throughout to the 1960s. In the 1960s, as I mentioned earlier, 1964, Cooper versus Pate, the court ruled that state prisoners have the right to file lawsuits in federal court alleging that prison officials have violated the U.S. Constitution and thus individual rights of each individual citizen, even though they are in prison. These lawsuits are filed under the federal statute, Title 42, Section 1983, also known as the Civil Rights Act, that was passed by Congress in 1871. So these rules and laws that were set up and established at the founding of our country, shortly after the Civil War of our country and the reorganization of our country, a way to set up and avail racial minorities and former slaves to sue the government for oppression has now been attributed to and applied to the various inmates of the various states. The early lawsuits against the United States and against the various states of the United States were plenty. As I mentioned before, they were a large number, a vast number of inmates that are suing the government for violations of their constitutional rights. And the floodgates opened, as I've mentioned, in Cooper versus Pate in 1964. Religious freedom was central to the Cruz versus Beto in 1972. This allowed the free exercise of religion and applied the First Amendment or the First Amendment protections of religion to inmates, because Cruz, who was a self-described Buddhist, filed lawsuits stating that he was not at liberty to worship his God as he saw fit, and as he saw other mainstream religions such as the Catholics, Catholicism, Protestantism, and Judaism. And he claimed a 1983 lawsuit, and the courts agreed. And the court found that while the Department of Corrections and the state did not have to hire a chaplain or build a chapel for every faith practiced by inmates, every inmate, including those belonging to a religion not considered mainstream, must be given reasonable opportunities to worship and exercise their religion. Okay. This has even found most recently the Texas Department of Criminal Justice Institutional Division is allowing inmates for the first time in, I don't know, modern history to grow a beard, because a beard is required in some religions, within Judaism, within Islam. They are commanded and ordered not to mar the sides of your face or the hair on the sides of your face. And that's been interpreted to, if you're going to be a good Jew or a good Messianic Jew or a good Muslim or a good Sikh, you have to be able to have a beard. And now TDCJ, based on the Cruz versus Beto, have allowed beards to exist in the prison system. Wolf versus McDonnell established due process for inmates. If there was to face, or if an inmate was to face any disciplinary charges, a loss of good time, be placed in solitary confinement, due process had to be set up. Due process consisted of the right to provide evidence in their defense, a right to notification at least 24 hours in advance, the right to have a neutral decision maker, a written statement of the evidence going to be used against them so that they can prepare for their defense, and to use a jailhouse lawyer in that defense. Procunier versus Martinez stated that the First Amendment rights protect individuals who are corresponding with inmates from having the letters that they receive from prisoners censored by correctional officials. Johnson versus Avery, the court upheld the right of inmates to obtain assistance from other inmates in preparing legal documents and lawsuits. Bounds versus Smith required that every prison must have a law library and or legal assistance programs to help inmates file 1983 lawsuits and to help prepare for their appeals so that they can get out of prison themselves. The list goes on and on and on. One of the major issues that we found was, Estelle versus Gamble, which stated that the Eighth Amendment was violated when officials deliberately or indifferently reacted to an inmate's serious medical needs. And another issue was overcrowding. Even more specifically, overcrowding was addressed as late as 2011, where the courts stated that the inmates were required to have a certain amount of space, a specific amount of space. But Brown versus Plata in 2011, the Supreme Court upheld a 3-judge Court of Appeals to implement population limits within the prisons, and specifically the California prison system, due to extreme overcrowding. Ruiz v. Texas was another overcrowding case. Hudson versus McMillan looked into inmates who suffer from non-serious physical injuries as a result of the officer's unlawful use of force by officers can allege cruel and unusual punishment. Again, Estelle stated that correctional agencies had to increase the resources dedicated to caring for inmate health. It was deemed, if you're going to hold an individual in prison, the courts declared that the state or the agency that's holding them in prison must provide them with a sanitary living conditions, sanitary food service. The prison had to be free of insect and vermin infestations. And you were not allowed to overcrowd the prison, because everybody is allowed to have their own specific certain amount of space when you're holding inmates in prison, and you cannot keep them and pack them in a prison like sardines. Because of the large influx of lawsuits, 1983 lawsuits being filed against the courts as a way to improve life within prison. The courts established one rule that was taught to me by Warden Justice. David Justice was his name. He was a senior warden for the FCI Big Spring, a BOP prison. Also, when he retired, and he was forced to retire in '57, he became the senior warden at Geo Big Spring. And one of the things that he would teach, and he taught me, and he would tell everybody that would listen to him, is that inmates are in prison as their punishment. They're not there for punishment. Some of the other rules and some of the other court decisions that came across was stating that corporal punishment was going to be unconstitutional, and it violated the Eighth Amendment. But a lot of court cases came through, and a lot of people were starting to claim that these lawsuits were becoming frivolous. So in 1996, the United States Congress responded to the explosion of inmate litigation, and they intervened by enacting the Prison Litigation Reform Act, also known as the PLRA. Supporters of the PLRA point to the burden that inmate lawsuits have imposed upon the court system. These complaints and this burden was brought forth by the National Association of Attorneys General, the Organization of States Attorneys. Others criticized the role of federal judges that were playing in the prison and jail conditions, and the judges were trying to dictate how prisons were being run. So the PLRA was established to make sure or to verify that inmate lawsuits were viable and they were not frivolous. They established an internal grievance system that was made available to the inmates where they could file before they could file lawsuits in the federal court system. And this is known as exhausting your administrative remedies. In Booth versus Turner in 2001, the Supreme Court ruled that prisoners must use the grievance system before filing a lawsuit, even in cases where they're asking for money damages. And the grievance system is not permitted to award money. Okay, so in order to obtain money and damages for the treatment that you've received while in prison, you have to file a 1983 lawsuit. The 1983 lawsuits, as we've discussed in previous discussions, does not always yield the types of success that are expected. So 14141 was also established as a way to file an injunction where the government will file and ensure that the practice and the procedure is stopped.